Thank you for joining us tonight. Today is November 9th, 2021. I am Matt Van Valkenburg, a council member of the Royal Asiatic Society, Korea. On behalf of the officers and council, I welcome you to our lecture. By way of reminder, lecture content does not necessarily reflect the opinions or positions of Royal Asiatic Society, Korea. The Royal Asiatic Society traces its beginnings to India in the late 1700s and was formally chartered in London in 1824 by King George IV. The Royal Asiatic Society of Great Britain and Ireland granted a charter to the Korea branch in 1900, the fourth year of the Gwangmu Emperor of Korea. RAS Korea expresses sincere thanks to our generous sponsor, Asia Development Foundation, for their continuing support. We especially thank our members who have paid their annual dues. Your dues provide essential primary funding for RAS Korea. Without your membership, we would not be able to host this lecture series. We would love to have you join us. It only takes a few minutes to sign up. Membership gives you the opportunity to support the world's first and oldest Korean studies organization. For 121 years, we have strived to explore and promote all facets of Korea's rich heritage. Members receive our annual journal Transactions. Members of the RAS Korea also are recognized reciprocally by most of Asia's RAS-affiliated societies, as well as the London-based original RAS. See our website at raskb.com for details, and a link will be posted in the chat box. If you are not a member, we request a one-time admission fee. Please refer to the donation page on your screen for PayPal and bank transfer information. This information will also be posted in the chat box. So we are joined tonight by Dr. Christopher Roberts. Dr. Roberts worked as a British lawyer for over 25 years and spent 10 years in East Asia between 1988 and 2003. Since retiring, he gained a PhD at SOAS and has published on the exercise of British extraterritoriality in Japan. In his latest book, British Extraterritoriality in Korea, 1884 to 1910, a comparison with Japan, published by Renaissance Books in June 2021, he turns his attention to Korea. After the lecture, there will be time for questions. Would you please welcome Dr. Roberts?
Thank you. Okay, I hope you can all hear me.
I can hear you.
Okay, good. Good evening. I came originally to this subject. Sorry. I came to this subject when I was studying British extraterritoriality in Japan. And during those studies, I came across the British Korea Treaty of 1883. And reading the provisions regarding extraterritoriality and treaty ports, it seemed almost as it was a recitation of all the problems that Britain had encountered, particularly in Japan with regard to extraterritoriality, and to a certain extent in China. And I therefore wanted to see just how extraterritoriality played out in practice in Korea. Also, I wondered why the mere mention of this treaty and extraterritoriality in Korea is not regarded as a blight, even today, on Anglo-Korean relations, whereas it is in both Japan and China. Why do we hear so little of British extraterritoriality in Korea? There is really one big case or famous case, which is the Bethel case. But that, in many ways, has little to do with extraterritoriality. It's a complex dance of relations between Korean independence movement, Britain and Japan wanting to establish its dominance in Korea. There are a couple of other cases which are perhaps of more interest, but I thought I would go through this. And the talk this evening is based upon my previous book, which Matt mentioned. And I will go first through the background of the treaty, some of the personnel involved in the whole operation of extraterritoriality, and then I will look at the number of cases that we see. Finally, there will be time for questions and answers. First of all, just a note on my sources. I have confined myself to sources in the UK. I have not gone through any Korean language sources. It's really because of my inability to read Korean. In all honesty, I'm not entirely convinced that it would add a great deal if I could access Korean sources, but the primary sources I've used are British government papers in the National Archives, the British National Archives, really correspondence between the British consuls in Korea at the time and the Foreign Office back in London. I've looked at English language newspapers published in China, in Japan, and in Korea. In Korea, there were 3 newspapers: The Independent, which ran for 2 or 3 years at the end of the 1890s, Bethel's Korean Daily News in the early 1900s, and the Korea Review. There was no newspaper covering the entire period published in Korea. There is very little secondary literature on the subject. Nothing has been specifically written on British extraterritoriality in Korea that I've been able to access. There is a book on the Bethel case viewed very much from a Korean perspective, and it sets it in the context of Korea. One of the points that all historians bemoan is the fact that we are missing all sorts of records. There are clearly references in the records I have to other records, but I just am unable to find them. They may have been destroyed in wars, earthquakes, or even fires in various buildings. Sorry, first of all, I should just discuss what is extraterritoriality. There were usually 4 elements in the unfair treaties, as they were called. The first was extraterritoriality. Its narrow legalistic definition is that a British subject who was in Korea would not be subject to the jurisdiction of the Korean courts or the Korean authorities for any crime or civil case. He could be punished only by the British consuls, who would hold a court and try him according to British law in that court. Yes, Koreans could bring claims and prosecute in those courts, but the law, the proceedings, and the judges were all British. Other aspects of the unfair treaties were the establishment of treaty ports, where foreigners had preferential rights to trade, set up business, etc. The foreign treaties also imposed tariff controls on Korea and limited the amount of customs duty it could charge, and it provided for foreign shipping to indulge in the coastal shipping trade. I would distinguish extraterritoriality from consular protection generally. Even today, it is quite normal for a consul of any nation to try protecting their citizens and negotiate if they have problems and try to protect them against abuse. But the general rule today is that any foreigner in Korea or any other country is subject to the local laws of Korea. Extraterritoriality, as I say, is an exception to that. By way of background, there were a number of open ports for trade. The key ones were Chemulpo, and I use the term Chemulpo rather than Incheon because it refers really to the very small old treaty port area of modern day Incheon, where the Japanese had a settlement, the Chinese had a settlement, and there was an international settlement. And probably a good third to a half of the British foreigners in Korea lived in Chemulpo. The second one was Busan and Seoul. In the 1883 treaty opened Wonsan, Chemulpo, Busan, Seoul, and a town on the river Han near Seoul, Yanghwanjin, to trade. The other ports in Korea were opened over the next 10 or 20 years to foreign trade. The background to this treaty is that in 1876, Japan came to Korea and imposed its own unfair treaty upon Korea and imposed extraterritoriality on Korea for the benefit of Japanese citizens and subjects. Britain monitored this partly from the British legation in Beijing, because of course at that time Korea was a vassal state of the Chinese Empire, but also from Japan. During the 1870s and early 1880s, Britain did wonder, should it come to Korea, but it really thought that there was little need to. Britain's concerns about Korea were driven really by the great game and its international power, global power politics with Russia. It did not want Russia to get into Korea, and a view supported very much by Japan. Then in 1882, the Americans came to Korea with a view to opening up Korea and establishing a treaty. In many ways, the Americans were concerned more with the rescuing of shipwrecked American sailors off Korea than trade. American trade in East Asia was relatively small, much smaller than Britain at the time. Britain then sent its admiral, Admiral Willis, who commanded the British Navy in Chinese waters, to Korea after the Americans, and he negotiated a treaty which was basically a verbatim copy of the American treaty. However, Parkes, who was the British minister or ambassador to Japan, we suspect clearly did not like Willis as on a personal level. He and many others attacked the treaty. There were various grounds for attack. One, the customs duties that the US allowed Korea were viewed as being very high. Secondly, the extraterritoriality provisions were vague. No account was taken of the geopolitical discussions going on with Japan at the time to revise extraterritoriality in Japan, and Willis conceded things to Korea and China, who was backing Korea, that would never have been granted in Japan. Also, Korea did not allow Britons to travel or trade in the interior of Korea. Also, the provisions in the Willis Treaty regarding opium were vague, and Parkes said that Willis didn't understand what he'd signed in Chinese, and in English they were unworkable. All in all, both the Willis Treaty and the American Shufelt Treaty were viewed as being creations of the Chinese, because the Chinese wanted to bring in Western powers into Korea, really to fend off Russian and Japanese influence in Korea. Parkes was attacking the Willis Treaty. I should mention that Germany signed a similar treaty at the same time, and similar questions were raised in Germany as well. China then overplayed its hand at the end of 1882 and negotiated what are called the Tianjin regulations with Korea, which basically tried to improve China's position in Korea and give China extraterritoriality in Korea. It called them regulations so that it could say it's not a treaty and we don't have to give these rights to anybody else. This was not being bought by anybody else. Two of the key characters in the story of the negotiation of the treaty. On the left here is Sahari Parkes, the British minister to Tokyo, who was about to be made British minister to Beijing. He was a diplomat of many years standing with experience of China and Japan. And he had 20 years of experience with the Japanese dealing with extraterritoriality and the problems. And he had very firm views on how extraterritoriality should operate in Japan, China, and if it was to be in Korea. On the right is William George Aston, who was a consul in Nagasaki working under Parkes. And he, from about 1880 onwards, studied the Korean language and began to familiarize himself with Korean culture, the language, and build up a relationship with Koreans. At the beginning of 1883, the British and the Germans decided that indeed Willis's draft treaty was of no use, and they decided that they needed a new treaty. Aston was sent to Korea to negotiate with the Koreans and to lay the groundwork for a new treaty. Parkes was appointed as British minister to Beijing with co-responsibility for Korea, and he then went to Korea in November 1883 to finalize the treaty, which was signed on the 26th of November. As I say, when you start reading this treaty, when it relates to extraterritoriality and the treaty ports, it is really a recitation of the problems that Britain had faced in China. And Parkes was determined not to have the same problems in Korea. And the treaty is undoubtedly very one-sided in favor of Britain. The Koreans agreed to it, I think because they saw Britain and other foreign countries as a means of playing off the Russians and the Japanese, who both had probably more pressing interests in Korea than the British. A number of issues came up. The first was exclusivity. Extraterritoriality relied upon the British consuls dealing with British subjects, and nobody else could. The Japanese view, very strongly put, had always been that if the treaty in Japan did not provide for extraterritoriality for Britain in a specific area, then it defaulted to the general position under international law of Japan having jurisdiction. Parkes fought that constantly in Japan, and in Korea he was going to have none of it. The 1883 treaty is very clear that any issue relating to British subjects will be dealt with by British officials, whether it's a crime, it's a civil dispute, it's a breach of Korean law, Korean regulations, whatever. There's no grounds for Korea to get involved at all. The applicable law, again, Japan said, well, even if you're here, you've got to apply by obey Japanese law. Parkes said, no, British law applies. And indeed, in Korea, it says the British subjects are only liable to British law, and such Korean laws as are made into British law by a regulation by the British minister or ambassador to Korea. So it's a very clear, Parkes is excluding the arguments that have been raised before. With regard to the protection of British-owned premises and ships in Korea, again, the treaty is clear. The Korean authorities have no right or authority to enter British-owned premises or ships in Korea, except with the permission of the British consul, which on the whole was given, but the Koreans had to go to the British consul to gain permission. There were, as I said, various treaty ports were opened. Cemeteries. In Japan, the Japanese said foreigners have no right to be buried in Japan. In fact, they allowed it, but they kept on saying you have no right. In the 1883 treaty, provision is made whereby the Korean authorities are forced to set aside land at the treaty ports for foreigners to be buried. Travel into the interior was a very big source of contention in Japan and China. In China, foreigners were able to travel into the interior, but in Japan they were not. In Japan, they were confined to a period of 10 li, or about 25 miles, from the treaty port itself. They could not go into the interior. In Korea, the regulations are much more favorable to foreigners. It was agreed that, first of all, within 25 miles of each treaty port, the British could buy land, rent land, build factories, warehouses, travel, no problems. Then up to a further 250 miles from each treaty port, they could travel into the inland of Korea for the businesses of pleasure or trade. And this was the key thing. In Japan, the Japanese were not allowing foreigners to go into the interior to trade, whereas the British in Japan and China very much wanted to trade in the interior. Another problem in Japan was opium. China, the treaty allowed for the import of opium, and the British could import opium into China. In Japan, the treaty always said that opium could not be imported. It was a banned substance. But the problem arose over medicinal opium. In the 19th century, opium, or laudanum, was often used as an opiate to sedate people for medical reasons. And medicinal opium, Parkes argued, was never intended to be caught by the ban on opium. In Korea, it is crystal clear. Opium generally cannot be imported, but medicinal opium could be imported, and a customs duty was levied upon it. Also, at this time, 1883, Japan was trying to revise its treaties with the foreigners and to abolish extraterritoriality. With Korea, partly because the Americans had agreed it, Parkes agreed a protocol, a separate protocol attached to the treaty, whereby Britain agreed that when Korean laws had been adjusted to be modern and clearly available, and Korean judges had become independent and reached the same standard of training as British judges, all in the opinion of the British, then Britain would abandon its extraterritorial rights in Korea. Again, this was very much the position Britain and to be fair, other Western countries were taking in the current negotiations with Japan at the time. Anyway, the treaty was ratified in 1884, in May 1884, and came into force. After the British treaty, there were treaties with the following countries listed there. They almost all followed verbatim the same format as the treaty with Britain. The only differences were France, in that travel into the interior, you'll remember that with Britain, it was limited to trade or pleasure. With France, they just said they could go up to 250 miles without that limitation. What that really meant was that missionaries could go into the interior of Korea. China in 1899 was forced by Japan after the Japanese-Chinese War to agree a new treaty with Korea, which actually provided for mutual extraterritoriality between China and Korea, so that Koreans in China had extraterritoriality. In none of the other countries did these rights occur. The British judicial regime in Korea, as I said, Britain's committing a crime or subject to a civil claim was subject to consular courts run by the British consuls. The background was that Britain passed in 1843 and 1890 some legislation to allow these consular courts to be established, and then various orders in council or executive regulations were enacted over many years to set up how these were to operate. And in practice, the situation in Korea was the same as in Japan and China. The consuls each had their own court. In the vernacular, it's usually called a consular court, but in the legislation, it's referred to as a provincial court. And each consul would hold a court for his own province or district where his consulate was. The consuls sitting as judges were supervised by, and there were appeals from their decisions to the British Supreme Court set up in Shanghai, which was run and organized by qualified and trained British judges. The Supreme Court also had an extraordinary jurisdiction in Korea, so that if a case was particularly complex, the Supreme Court could hear it as opposed to the judges. Differences in both Japan and China and Thailand, which also had consular courts, there were professional, legally qualified judges who heard the most complex cases. There were none in Korea. The British didn't send any there. There just wasn't a sufficient demand. The other issue is that in Japan and China, as I said, the consul's authority was limited to his specific province or port, whereas in Korea, the consuls had authority over the entire country. There was no practical consequence other than the fact that the vice consul and the consul general had a concurrent jurisdiction over Korea, and there was no appeal from the junior vice consul to the consul general. The appeal was straight to the Supreme Court. There were differences of jurisdiction which were of no practical consequence in Korea. For example, the consuls in Korea had no jurisdiction over any maritime or shipping law matters, over matrimonial disputes, or lunacy when somebody went mad or insane. In fact, no such cases arose in Korea, so it didn't matter. In terms of physical structure, no courtrooms were built, whereas in Japan, a purpose-built court existed in Yokohama, and in Shanghai, there was a very large Supreme Court building built adjacent to the British Consulate General in Shanghai. In Korea, the consuls just sat in their own offices, and everybody would come into their offices and they would argue and the case there, and that's what went on. And there was no great formality. If the Supreme Court came to Korea, as it did on 2 occasions, then there would be formality with formal court dress, with judges wearing wigs and gowns and so forth. there was no British legal profession in Korea. There was insufficient demand, unlike both China and Japan, where there were a number of British lawyers practicing. Also, Britain did not establish any jails to imprison British subjects in Korea, again, unlike China and Japan. Looking at the consuls, just so you've got an overview, at the apex you had the minister or the ambassador. In Korea, the minister or the head of the diplomatic representation was always, until near the end, he doubled up as the minister to Beijing. He was the non-resident minister to Korea, except for a period from 1898 to 1905, when there was a separate minister to Korea. The day-to-day affairs were run by a consul general based in Seoul and a vice consul who was based in Chemulpo. There was usually an assistant or a junior consular officer also based in Seoul. And as I said, Aston was appointed the first consul general, and he was joined by somebody called Richard Carles, who was the first vice consul. After them, there was a period of acting consuls and so on. Another person we come across is a British constable. Most consulates where there was extraterritoriality had a British constable whose job was more or less like a local policeman. He was a bit of heavy muscle for the consul to maintain law and order amongst British subjects in Korea. He also doubled up as a bit of a clerical officer and doing things. Another character we come across was the Crown Advocate, who was basically an independent lawyer, but he was the government legal advisor and is like an attorney general in most governments today. He provided legal advice to the minister, the consul general, and he also prosecuted criminal cases. Until 1903, with the exception of Aston, who was the first consul general because he did speak Korean and had helped negotiate the treaty, everybody involved in Korea came from the China Consular Service. On the left, we have Richard Carles, who was the first vice consul. After him, as I said, there was a hiatus until 1889. Carles and Aston went home in 1885, and for the next 4 years, it was a succession of acting and provisional people who never stayed more than 12 months. Then in 1889, Hillier came, and he's as acting consul general for 7 years until 1896, when he retired and was replaced by the fellow on the right, Sir John Jordan, who was the only person who was appointed minister to Korea. He started off in 1898 as in 1896 as the consul general. He was promoted to be chargé d'affaires and replaced the minister in 1898. He was appointed minister in 1901, and he retired, or rather was promoted to be minister in Beijing in 1906. At the time, the Japanese established a protectorate over Korea, whereupon the post was downgraded back to a consul. That's the background. Now, just looking at the caseload, I make a comparison with Japan, just so you can see what a startling difference there is in the number of cases heard, well, not even heard, but that arose in Korea compared with Japan. over a 40-year period, there were nearly 6,500 cases that I can trace in the records in Japan. In Korea, 24. That's a comparison of 1 a year to 160 a year, which is a dramatic difference. And you think, my God, what's going on here? It is a startling difference. And we need to investigate this further to explain and find out why, because in practice, I will go to show that there wasn't such a great difference so far as Britons resident in Korea or Japan were concerned. Japan, I've got the figures. China, I've never seen any total figures for the caseload in China, but they would be far, far higher than for Japan. If I look in Japan at the criminal caseload in the last 20 years, we have just over 1,000 cases. I take away from those what I call shipping offences, which are all offences which occurred on British flagged vessels, either sailors who were absent without leave, they refused to obey their officers, they deserted, or the ships mistreated the crewmen. These were all really offshore and did not concern Japan. If we ignore those, we're left with nearly 400 cases which arose from events onshore Japan. But from these, over 200 were sailors as defendants, which left just 154 British residents who were charged with a criminal offence in the last 20 years, which is 7.5 residents a year, which is very different from the 160 cases a year. So you can see already it's much smaller. In Japan, again, on the criminal side, we had 350 civil cases and nearly 100 shipping cases, strip out where you had sailors as the defendants, usually petty, not paying for goods. You've got about 200 civil cases or 11 civil disputes a year. If you now compare Japan with Korea, looking at residents, you have 374 cases in Japan to 23 in Korea, 23, 24, 20 in 1920 to 1 a year. But then you look at the population, the British population in the two countries. The British population never got above 100 people in Korea during the extraterritoriality period. And it was, in fact, less than that. So it never exceeded 10% of the population in Japan and was nearer 5%. So you would expect the caseload involving residents to be that much less. So the raw figures are easily explicable. Then you ask, why was the caseload so much lower in Korea? And the reason is the absence of British vessels and sailors. Although Britain was the largest maritime nation in the 19th century, and its ships traded everywhere, they hardly ever came to Korea. And the British Trade Report of 1889 reported that the red ensign, or British ships, is once again conspicuous by its absence. Although at the time, British goods formed 3/4 or more of the foreign imports into Korea, they did not come to Korea in British ships. And the trade was in the hands of the Japanese, about 80%, and the Chinese, the other 20%. And all the British goods were imported into Japan or China, and transshipped in those countries into either Japanese or Chinese ships, or in the case of North Korea, the northern parts of Korea, they were brought over the border, the land border, by Chinese merchants. And we saw in Japan how the shipping cases dominated. So that explains, in some ways, also the case that much smaller British population. The population was just 10 Britons in 1883. It rose to 51 in 1893 and only reached 85 in 1909. Also, we need to consider the completely different makeup of the British community. In Korea, over half the community were missionaries. And, you know, almost by their nature, missionaries are not going to be prosecuted for criminal offenses, and they're going to not have many civil disputes. And this belief is borne out by Osaka in Japan, where all the British residents in Osaka were missionaries. And there were no cases in Osaka. So this makeup makes a big difference. In the early 1900s, there were, say, 85 people, Britons. 20 were children. The rest were half male, half women, and it was mainly missionary, half missionaries, and the other half were either government officials, British government officials, British officials working for the Korean customs, a few technical people working on the railway, the Korean postal service, and the Korean telegraph service, and one or two professionals. And there were very few other Britons there. The other thing is there was only a minor British trading presence. There were two Britons who traded in Korea, one William Bentley in Chemulpo and Holmes Ringer, a Nagasaki-based British company. But again, they were both trading from Japan into Korea. Once you take all these factors into account, you understand why the caseload was so very different in Korea. So just looking at the criminal cases, we've got about 9 criminal cases in Korea. In Japan, it is impossible to go through and discuss every case one by one. There are just too many. In Korea, it's actually possible. And the breakdown is broadly similar. There are assault, public order offences, and that's, you know, half of them. There was one manslaughter case in Korea. There were several manslaughter cases in Japan and only one murder case. But assault and riot and just public brawling in the streets was common in Japan. There were 4 issues where that arose: fraud, theft. There was a alleged case of illegal logging. And there are 2 cases of sedition in Korea. There's a Bethel case. They should be put on one side. They're not typical. But of the public order cases, 2 occurred at the very beginning, one before the treaty came into force, and so the British had no jurisdiction. One, we think, we don't have any details. There's just an oblique reference in one of the consular files to a Briton having been deported from Korea in 1885. Doesn't explain why or what for, no other record. So that's 2 down. Then we have really the consular constable O'Neill was prosecuted for manslaughter in 1898. Another consular constable, Shaw, in 1885, was not prosecuted, but he was deported from Korea, just put on a British ship to China after he'd had a punch-up with the American constable in Chemulpo. And they'd both been drinking, and they were just got out of the way to save embarrassment all around. The fraud case was dropped because the witness would not stay around. It was a British civil servant from India visiting Chemulpo on holiday, and he recognized another Briton there and said this Briton had been committing fraud around East Asia, but nobody could prove it, and the Indian civil servant wasn't prepared to stay, so it dropped. The illegal logging case, one of the Korean provincial governors accused a Briton hagraman of illegally logging and rustling cattle from northern Korea into Russia, where he lived. Well, hagraman said, A, I haven't been in Korea in the last year. B, the local governor knows who I am. And this is clearly a case of mistaken identity. So nothing further happened. And in fact, we have only 4 cases that actually went to court, but we have 9 complaints. There were no dramatic differences in the makeup between Korea and Japan, and I suspect China. In Korea, no women were prosecuted for committing a criminal offense, and there were no women as who were complainants either. In Japan and China, there were they were not common, but they did occur. And apart from Bethel at the very end, there were no repeat offenders, whereas in China and Japan, you find a number of the Britons are repeat offenders, usually for petty offences. As I've gone through that, so on the civil caseload, again, it's very similar. There's no great surprise in how things are made up. The first case was a complaint, a Japanese person in Busan was complaining that Britain had not paid him for goods and lodging. This was before the treaty came into force. Britain had no jurisdiction. The next case happened in Chemulpo, where Briton Thomas was sued for money he owed. I don't know any more about the case because we know nothing other than there was a judgment against Thomas. And the only reason we know there was a judgment against Thomas is that he ran away from Chemulpo, and Carles, the consul, needed to get him back. And Carles asked the Korean authorities to look for Thomas and bring him back. And Carles wrote, I told the Koreans they must not treat Thomas as they would treat a Korean, which is to beat him up and to tie him up and carry him on bamboo poles back to Chemulpo. Well, what happened? That's exactly what happened. That's what the Koreans did. And we know more about Carles trying to get the Koreans punished for that than we do about the case involving Thomas. It's an infuriating case where we know there was a case only because of something else. The only shipping related case was again in 1884. A Korean said that some goods which he'd had shipped from China to Chemulpo had not been delivered by Jardine Matheson. The case never came to court. The consul just went to Jardines, who said, well, yes, if the Korean can prove that he shipped the goods and has paid the correct customs duty and has a bill of lading, of course we will pay him. So there was no great issue. There were 2 property disputes, both involving a chap called Emberley, and neither came to court. The first one was a dispute by the Korean authorities wanted to recover possession of Emberley's offices, which he was using to print a newspaper. Emberley said that he'd bought these offices from the Korean-American Philip Jason, and Jason had acquired these premises direct as a gift from the Korean king. Jason was an American, therefore the claim arose through an American, so Britain had no jurisdiction anyway, but Emberley said if it's tried in the American court, he would abide by any decision. The next dispute involving Emberley involved the Station Hotel, which he managed and ran, and he'd opened up on one side 3 windows, and his neighbor, who was a court official at the Korean Emperor's court, complained about loss of privacy and that the roof was dripping onto his land. Again, no case. The British minister Jordan met with the governor of Seoul and the complainant and Emberley and reached an agreement. The agreement was the windows would be blocked up, but that Emberley was right, that under Korean law, the boundary of the property is where the drip comes from the roof, apparently. And he'd researched this, and that was so there was no dispute. Then there were 4 cases of estate administration. Somebody died and their estate had to be wound up. 2 were handled formally with a formal grant of probate. The others were handled unofficially. The other cases, I say others, because we know that in 1908, there were 3 other cases that were handled informally by the British consul. What they were about, we've no idea. We just know this because the British consul wrote to the Japanese Residency General in response to a request as to how many cases were there. He said there were 3 cases, but they were all settled informally. So we know very little about that. As I say, apart from 2 estate administration cases and the 1 case against Thomas, none of the civil cases came to court. Just quickly in terms of appeals, there were no appeals regarding criminal matters. You could only appeal on a point of law from the consul to the Supreme Court in Shanghai, and then to the Privy Council in London. On the civil side, there was, the second case, there was 1 case, the Koreans brought a case against somebody called Stripling in Chemulpo for the non-payment of ground rent. And there was a technicality, Stripling won, the Koreans lost, and they threatened to appeal. The British minister simply told Stripling to pay, and he did eventually. I'll skip over the other issues. I'll just mention, was the system biased? No, although there was clearly bias and prejudice against Koreans and natives in social attitudes, there wasn't, I don't think you could say that the administration of extraterritorial justice was in any way biased or prejudiced. None of the cases suggests bias, and the 1 manslaughter case where the defendant was acquitted, the Korean-owned independent newspaper reported that the case was very thoroughly examined, was gone into in great detail. The governor of Seoul, who was at the court hearing, was allowed to ask questions. He asked many questions, and there were no complaints about that case. So one's got to take the view that the system did operate fairly. I'm not saying that there were no societal biases, but in terms of the procedures in the courts and how they operated, they were unbiased and they were neutral. Of course, the whole bias was the fact that Koreans had to go to a British system. I will skip the next effort and just say that extraterritoriality ended automatically in 1910 when Korea became part of the Japanese Empire. And this was because extraterritoriality had finished in Japan in 1899. And so as Korea was now part of Japan, no extraterritoriality. And both the Japanese and the British had learned lessons about how to deal with tricky issues, and they were dealt with. Conclusions. The Anglo-Korean Treaty of 1883 was really the high point of British extraterritoriality and the statement of extraterritoriality. It was downhill, in a way, all the way thereafter. The British experience in Korea was actually not so very different from that in China and Japan, once you explain why there were so few cases. The reason extraterritoriality has not been a problem in Anglo-Korean relations is that there were so few cases, and Britain was only a small player in Korea. The main problems Korea had during this period were with the Japanese, and that British were not there. I just flag some areas for future study in case anybody is interested. One, as you saw at the beginning, Britain was not the only country with extraterritoriality. I've not read anything about any of the other countries and how many cases there were. A comparative study would be interesting. And finally, it would be very interesting to get a Korean perspective on the whole business. And really, are there any questions? And that's just the back of my book, and that explains it. But I go back to the Korean emblem and the royal symbol of the period. So, sorry for taking the full hour, and I hope I've given you a quick overview.
Well, thank you very much. If anyone has questions, they can use the raise hand function. I guess I might maybe just end the share screen. And I guess if you could...
Shall I stop sharing? Okay.
Yes, that might be helpful, so
okay,
I can
fine.
see everyone here. So yes, if anyone has questions, you can use the raise hand function or raise your hands or write them in the chat box.
If I might ask a question, if you can hear me.
Yes.
Thank you, Dr. Roberts, for a fascinating talk. I have a question in 3 parts. I'm not sure whether you might find the question very trivial or you might not be able to answer it, but it's a genuine interest for me. You mentioned various people, Parks, Willis Ashton, William Bentley, Carles. I wonder, by looking at all these records, whether you have any observations as to any of their personalities, who they were as people. Did any particular person stick out? You mentioned perhaps disagreements between Parks and Willis over the treaties. So I wonder about any of the people and personalities. That would be the first part. The second part, you talked about the makeup of the British community, reaching 85 in 1909, predominantly, well, missionaries and children and government officials. Why was it like that? Why was that the community in Korea and not as it was in Japan, and from your perspective? And then the third part would be, looking at these records and your interpretation, what do you imagine life was like back then? And again, I'm not sure you're able to understand that through looking at those records, but what do you imagine the life these people were living in Chemulpo, or that part of Korea, was like during those times? That's my 3 questions. Thank you.
Okay, fine. On people, well, Parkes was clearly a very dominant and forceful personality, described as a workaholic and so forth. In fact, he died in early 1885. He'd worked himself arguably into an early grave. Aston was, I get the impression, an academic. He retired. He'd written on Japan and Korea. His health wasn't very good when he left Korea, and he just retired, but was an academic. The other three big people, I would say, in Korea were Hillier, who was from 1889 to 1905. He actually seemed to have quite a cushy number. He didn't work terribly hard by the sounds of things. A lot of the work seems to have been left to his juniors. There just wasn't a great deal of work around. He was responsible for supervising the building of the then British legation there. He had a torrid time in Korea in that his wife had an affair with a young British official in the Korean Customs Service. And when he went back to the UK, they ended up having a divorce. He sadly left Korea in 1896 because he was going blind and he needed an operation. And the operation, obviously, in those days was highly risky, and he could have been permanently blind, but in fact, it did work. And he did have another burst of activity advising the British military in Beijing at the time of the Boxer Rebellion. Then Jordan was clearly a dominant figure. He was the only minister to Korea. He was quite forceful. Interestingly, Hillier and Jordan and Jordan's successor as Consul General Coburn, they had all been Chinese secretaries of the legation in Beijing. And by 1895, certainly, Seoul was regarded as a plum post in the China consular service. I think because as a consul general, you were running your own show, you were away from the minister, and you got paid quite a bit of money by consular standards. Then what was life like? In fact, an examination of these cases and extraterritoriality in general and reading cases is a very good way of getting into what life was like. And it was not that busy. I think it wasn't a rushed and busy life. I suspect there were a number of, it was quite confined. There were small communities, obviously. And there was a degree of hardship. You didn't have air conditioning and think weather was hot or very cold, and disease was prevalent. And the missionaries were often medical people, and they brought medicine to Korea. In terms of, I didn't discuss, and strictly it's not a part of extraterritoriality, claims or complaints by British people against Koreans. And you did find there was a case of a lady, I assume a missionary, bicycling around Korea when some Korean soldiers took to throwing clods of earth at her. And, she complains, and there's a complaint, and one of the soldiers gets severely thrashed as a punishment. The complaint is he was drunk and so forth. And the British did, particularly those who were in the mining industry in the interior and the missionaries in the interior, there was a degree of physical risk. There was always, would they be attacked and so on, because they could not rely upon the Korean local authorities to protect them. Basically, the writ of the Korean central government just did not run outside Seoul. it shows how the Korean government worked in some way. That it's a bit like China, it's the same issues in China. Japan, on the other hand, but after 1870, if Tokyo said something, the local governors did what Tokyo said. You know, there was a control, and it was just administration, and it spoke to Korea. So yes, viewing these cases and reading them does tell you quite a bit about life. Anyway, sorry, long-winded answer.
Perfect answer. Thank you very much.
No, sorry. Samuel.
Oh, yeah, you need to turn your mic on.
All right, can you hear me?
Yes.
Yes.
Okay, thank you very much, Dr. Roberts. I was just curious if I understood you correctly. It seems like the one matter where the Koreans kind of stood up and opposed some of the demands was on the opium issue, where it seems like they were the Brits did not quite get their way on that. And I was just curious why that, it seems like that one issue, the Koreans were able to withstand the pressure to.
I'm not actually sure that that's necessarily right. I've not read a lot about that issue. Of course, China, opium was allowed. It was very, I mean, frankly, Britain needed to export opium to China for the financial economy of India.
Right.
Japan had always flatly refused to allow it to come in. Medicinal opium is really a byproduct. And I don't think there was any great push by Parks or anybody to have opium in Korea as a whole. But they did want to have medicinal opium because it was basically a drug that people needed for medicine. And interestingly, there was, I think in the late 1880s, a circular went around from the Korean Foreign Office to all the there were only about 5 or 6 foreign consuls in Seoul, saying opium is banned, you're not allowed to have opium, and naughty, naughty, and please tell all your subjects not to deal in opium or allow Koreans. Although Hillier said, fine, he will tell everybody, all the British subjects, he will tell them, but he did say, you, the Koreans, are not allowed to go into anywhere where any British-owned premises where opium may be smoked. But he said he didn't think that there were any such premises. And it's not clear that there were, in fact. I mean, let's face it, half the population were missionaries.
Missionary, right.
You know, we must assume they weren't doing it. Unlike Japan and the seaports in China, none of the bars and drinking shops were owned by Britons. So, you know, they wouldn't be hosting it there. Now, it may well be that this order was aimed at the Japanese, who of course had a large settlement there, and the Chinese, who may well, you know, in both of those cases, may well have had low-life bars where there was opium going on, and Koreans going into those places. But it wasn't an issue for the British. And of course, at the time of the treaty being agreed and ratified, questions were asked in the British Parliament as to what the position was with regard to opium. There was a very strong anti-opium lobby in Britain. You shouldn't think it's all one-way Britons were pushing opium. Right. There was an anti-opium lobby.
Interesting. Thank you for that clarification.
Okay, fine.
Yeah.
And, Michael, you have a question? Oh, you turned it on and you turned it off.
Ah, okay.
Yes.
Okay, good. This is actually my debut on Zoom. David Tizard,
Welcome.
and I'm sorry I'm in soft focus. I don't know why. As I see myself, I'm in rather like an aging Bollywood star in soft focus. But David Tizard asked about other British personalities involved. And, he mentioned William Aston, and there is a biography of William Aston, which by Kevin O'Rourke, which he published about 5 years ago. Sadly, he died recently. But he was a very, very interesting character, way beyond what has been talked about here. And he was one of the first Westerners to write about the Korean language and about Hangul. So if anybody can get this book, it's a very good read.
What is the title of the book?
The title is William George Aston in Korea.
Okay.
And I did hand out some copies when it came out to various people in the RAS, including Brother Anthony. So if anybody sees me, if anybody wants to get in touch with me, I'll lend it.
I would also mention there was a recent book published, I think, by somebody in London on the Hillier family, who are broadly 3 generations in China, who talks about Walter Hillier, the British minister in Korea, amongst his other relations, to their family that served in China really for 3 generations. There are books on these people, and of course William Richard Carl's own book on his travels in Korea is available in reprint, and Isabella Bird's book on travels through Korea.
Do we have any other questions?
I mean, if anybody has any questions, just drop me an email line and I'm very happy to answer them.
I was kind of curious about, there's an article, it's about 15 years old. It was by Alexander Cockburn. It was in The Guardian. And he was writing about his grandfather, Henry Cockburn, who
Yes.
was consul, vice consul. He was
Consul General. He tried Bethel, yes.
But there's an interesting case with Yang Ki-tak, who was one of the journalists at the Korea Daehanmye Ilbo, who or Daehanmye, I forget the name.
Korean Daily News.
Yes, and he was arrested by the Japanese because that newspaper was housed on, I guess, British property, and because people at the consulate knew him, they went to see him in prison, and he'd clearly been tortured, and then he was accidentally let go, and he fled to the British legation, and the Japanese said that was a mistake, give him back, and Cockburn absolutely refused, and because he wanted assurances that he would not be tortured. The Japanese couldn't really believe it. They couldn't believe he was actually taking this seriously, this issue of torture. And eventually his superiors in Tokyo kind of forced him to turn him over, though he did get assurances. Though it was interesting, something that Alexander Cockburn pointed out was the use of the language. One of the cables was titled rendition of Korean journalist. So the use of that word to mean turning over someone to be tortured by another government. Which was...
Well, I think that's a slight handing over to be tortured is a slight misnomer. The case, I didn't go into that case, comes out of the whole dispute with Bethel. And, you know, you could have an entire lecture on Bethel, and I didn't want to dominate that. But he was an example that where the Korean authorities could not enter British-owned premises without the consent of the British consul. And you're right, he had been arrested. He was on the premises of the newspaper after Bethel was no longer around. And I think Bethel may have been in prison by the British at the time. Yankee Tak was left the British-owned premises by a trick, and he was then arrested and, as you say, tortured in jail, and he was let go by a mistake, and he went back to the newspaper offices, and the Japanese asked for him to be released. And yes, you are right that Coburn, who of course came from the China consular service and did not like the Japanese and what they were doing in Korea. You've got to bear in mind that he really had no sympathy with the Japanese. He was told basically by London and his superior in Tokyo that yes, you've got to release him with assurances that he will be properly looked after, he'll have medical treatment, blah, blah. And the Japanese did honor those assurances, and the Yankee Tak did then have a fair trial by 3 Korean judges, but the Korean judges were all Japanese judges masquerading as Koreans. And actually he was acquitted in that trial. The prosecution just couldn't provide adequate evidence, and it was clear that he hadn't been guilty of that, and he was then let go. And it may be, I think, that one reads very little about him subsequently. The whole experience may have so scarred him mentally that he kept a low profile. But that case is an example of the limited extraterritoriality of British-owned premises that, you know, it required the consul's consent to go in there. And the Japanese were very conscious of that, because earlier that year, they had invaded the newspaper premises and without permission. And the Japanese police superintendent in Seoul was sacked and sent back to Japan because he should never have done that. It is an interplay, but Bethel was basically an embarrassment to the British, and they just wanted to get rid of him. They were very happy to get rid of him, but they wanted to do it in a proper way. But there is a very long story on Bethel.
All right, thank you. Do we have any more questions?
I could just mention, I'm going to share in the chat a copy of the article that you might have been referring to. Steve Shields wrote, previewing this lecture actually, about Bethel.
Okay.
So that's it. I don't have any comments or questions other than that. Just check it out.
Yes, if that's of interest, that is in the chat box. Well, if there's no more questions, I guess I'll say thank you to Dr. Roberts for a very interesting lecture. And I'll just make a few announcements before we go. We have the upcoming colloquium with the EFEO at Korea University. Oh, sorry, it's usually at Korea University, now it's online. So that's November 18th at 6 p.m. and pre-registration is required to receive the link. So if you look at the RAS Korea website, the email address of the EFEO is there. So this lecture for the colloquium is by Christophe Duvert and presents a historical overview of the iconography of justice in the context of South Korea and discusses representations of justice understood both as a principle and as a judicial function. It focuses first on traditional figures, the Haite representations of justice in Korean Buddhism, paintings and photographs of Joseon and the Daehan Empire, and explains the social and political contexts of the production of these images. Then it analyzes the official representations of judicial institutions in modern and contemporary times, mainly badges, allegories, and logos, to draw the institutional imaginary, the prescribed image of justice, which offers a synthesis between embodied justice and conceptual justice, and shows that the current portrayal of justice is the result of a process of hybridization of images that reflects the country's multi-layered cultural heritage. So the presenter, Christophe Duvert, has lived in South Korea since 2007, where he shares his time between teaching and university research. He is the author of a French book translated as The Ways of Justice in South Korea, which was published in 2021, and he holds a doctorate law degree and is an associate professor at Sungsil University in Seoul. And our next lecture here online will be on November 23rd at 7:30 p.m. and will be by Dr. Gongdan Oh, who will be sharing about her book, North Korea in a Nutshell. Dr. Oh is an independent scholar. She was formerly a senior Asia specialist at the Institute for Defense Analyses, a non-resident senior fellow at the Brookings Institution, and a member of the political science department at the Rand Corporation. She has taught courses at the University of California at San Diego, George Washington University, and the University of Maryland University College in Asia. She is the co-founder and former co-director of the Korea Club of Washington, D.C. So that will be our next lecture, number 1454, in 2 weeks' time. So thank you, everyone, for coming tonight, and thank you, Dr. Roberts, again for your presentation.
Thank you for listening. Thank you for your question. Bye-bye.
Bye-bye.